I'm Tony Kearns. It's a great pleasure and a privilege to be here. I came here because I had colleagues from Israel visiting us some months ago. Tal, who you've just heard speaking, a very good antecedent to my talk, and Udi Susser, who suggested I might like to come and see the services in Israel. And not only did I get a chance to see the services, but subsequently I was asked by Dr. Oren Osman to come and lecture at this August conference, and I'm delighted to be here. I haven't been in Israel before, and I've always wanted to do it, and this is a perfect excuse. My theme today is a slight variant on the subject matter that you had presented to you. I'm focusing on a specific topic of insanity. Insanity is a great word. It suggests a kind of uncontrolled madness, and I'll talk a little bit more about that. I've heard a little bit from Tal about stigmatization, and the word insanity itself, carries all kinds of fairly dreadful connotations, but it's still a phrase that's in use. Just a bit about my own background and about our service. What you see behind me there is a picture of our hospital. As you can see, it's a handsome building. That's only part of the building. The whole building is about 2.5 times that length. It's a long Victorian building in the suburbs of Dublin, the pleasant inner suburbs of Dublin, in a nice middle-class area, surrounded by beautiful grounds, but also surrounded by a massive brick wall. So it has, from the outside, a rather intimidating impression, but on the inside is actually really a very pleasant place until you get to the wards, which are, again, Victorian. It is a Victorian hospital. It was opened in 1850 as part of a programme of what was then called criminal lunatic provision within what was then the United Kingdom of Great Britain and Ireland. Ireland, as did Israel, obtained its independence from the United Kingdom as a free state in 1948. So we have that in common. But at that stage, there were 4 criminal lunatic asylums. There was that one in Dublin, and there were also 3 on the mainland of Britain, and that was Broadmoor was one of them. There's Carstairs in Scotland and Moss Side in Liverpool. All 4 hospitals are still actively in operation. We have on the hospital side some 94 patients in the core service, and the core service consists of an acute admission service, a medium cluster, that is medium secure level of care, and a recovery and rehabilitation service. The last is the one through which the patients move on their way out to step down and community facilities. Unfortunately, as things currently stand, there is no separate pathway for women, so they have their own ward, which has to contain all these elements in it. The part of the service that I belong to is the Forensic, Intellectual and Developmental Disability Service. That's a relatively new addition. It's the first specialist area in the service, and it was opened just coming up to 3 years ago. I had worked previously for 30 years in the National Health Service in the United Kingdom, and was invited back to participate in the opening of this. I have some form in this regard, in that in the United Kingdom I was responsible for opening the first public sector medium secure service for intellectual and developmental disability. So I guess that's one of the reasons I was asked to come across. So our service is relatively new. We're feeling our way through it and looking at establishing the various elements of it. As it is at the moment, we have access to the various parts of the existing general forensic service, that is to say, admission through the acute unit, access to other parts of the medium cluster of care, and use of the recovery and rehabilitation facilities. In fact, since we've been open in those 3 years or so, all of the patients we've discharged from our unit, which is a medium secure facility, have moved into the community. The big development in our service is that we are moving on to a new site. The present one, being a Victorian building, was built with very different precepts in mind. Although it has individual rooms, interestingly enough, they mostly don't have ensuite facilities. They are very much like if any of you has ever been to a Victorian prison, similar to that in the internal layout. They're cells rather than bedrooms. So that has to be conformed to modern usage, and that's quite difficult. We have two more modern units built in the 90s, but even they're now we're getting somewhat threadbare. So this unit will have, in addition to significantly more modern facilities, a significantly greater number of beds. And it will be just outside the city, on the edges of Dublin. So why did I choose insanity? Well, it's as I said, it's an interesting topic. It's one that crosses the boundary between law and psychiatry. The word insanity, I think I have a slide saying it later, is illegal rather than a psychiatric term, and it has various connotations. Nonetheless, the concept is one that has international currency. It also causes considerable pressure on resources. In our service, which is the one, of course, I'm speaking about, for every case that is mooted to have insanity, there are at least 3 assessments, often more, and considerable involvement of the time in required for those assessments on the part of a number of professionals, and that leaves aside the legal part of it, which is also very considerable. It involves a great deal of court and lawyer time as well, not to mention the administrative elements. So the background to this, of course, is that a person who is mentally unwell, and there are various phrases used for this over the years and across the world, should not be held culpable for an act which he or she didn't understand or over which he or she had no control. There are variations on the themes of this, of being not guilty by reason of insanity, which is that concept. And various elements have been considered in coming to this determination. You will probably be familiar, most of you, of the McNaughton rules, which form the framework for the verdict of insanity in, well, what is a lot of what are formerly Commonwealth countries and other countries sharing that heredity. And they were formulated in 1843, following the case of a man who tried to kill the British Prime Minister, but mistakenly killed somebody else. The other person was one of his administrative staff, and sadly died instead of the Prime Minister. So this man, McNaughton, Daniel McNaughton, who was a man from a humble working class background, was deemed not to be responsible for his actions and therefore insane, and the court delivered this verdict. There was considerable debate about it at the time, and the courts were required to formulate their views, which they did in this rather neat and tidy framework of words, which still holds, although the expressions are somewhat old-fashioned, still holds to this day and is still in use in very many jurisdictions, commonly enough in the United States, certainly in the United Kingdom, and to some extent, as you'll see, in my own country of Ireland. So what it said is that the person suffered from a defect of reason, and we enter into the debate what reason is, indeed what defect is, from disease of the mind, and disease of the mind is what we probably call mental disorder, and again there are debates around what that means, so as not to know the nature and quality of the act, and that's something about which lawyers and psychiatrists have a great deal of time discussing, or that if he did know it, that he did not know what he was doing was wrong. So, as I've said, insanity is a legal term. The phrase special verdict is often used to talk about this decision. Special verdict because it's a verdict neither of guilty nor of not guilty, but somewhere in between, in that the person is not guilty, but not guilty by reason of the excuse of insanity. And that leads to, in almost all jurisdictions, to further disposal. And that is what I'm interested in today. In Ireland, until 2006, we operated along the same basis broadly as the United Kingdom did until the early 90s, which is that if a person was found insane by a court and by a jury in a court, the person would then be sent to hospital until, as the British expression had it, Her Majesty's or His Majesty's pleasure be known, which is, I think, a wonderful expression. I entertain the idea of the monarch somehow suddenly becoming pleased and discharging the person, but It apparently doesn't work like that. In Ireland, we had a variation on that theme after independence. It became the province of the government to supervise these. And you can see here behind me, I just thought it would be of interest to anonymise and copy an order. And that order, as you can see, provides for the disposal of the person to the Central Mental Hospital, the one which you've just seen pictures of, and they are then under the supervision of the Minister for Justice. And there is common ground, as I understand it, with what happens here in Israel, in that there's a dialogue between mental health and the criminal justice system. Before the new act, which I'm about to talk to in a moment, was introduced, the hospital had very much a kind of penal quality about it. So the effect of the criminal justice system was the larger effect. With the advent of the new act and with more liberal and modern thinking in psychiatry, again of the type we've just heard about in relation to the Israeli practice, the hospital has acquired, as it should do, the status of being a clinical entity rather than a custodial one. So that leads us to the new act. In 2006, we introduced a new act which incorporated within it the criteria for insanity. And as you can see in my slide, for a person to be found insane, and the arguments have to be offered and proven in court before a jury which decides. The jury is a body of 12 people, as you will probably be familiar with. And the jury then has to listen to the evidence and determine whether it's convinced that the person is insane. The criteria that are offered to the jury, which has to decide on the balance of probabilities, so it's more of a civil test than a criminal test, on the balance of probabilities, are that the person was, at the time of the committing of the alleged offence, suffering from a mental disorder, and that the mental disorder was such that he or she did not know the nature and quality of his act. As you can see, that's taken pretty well straight from McNaughton. Did not know what he or she was doing, again taken from McNaughton rules. But in addition was added the extra element of was unable to refrain from committing the act, which is the bit that I became interested in. This doesn't apply internationally in all jurisdictions. It doesn't apply in the United Kingdom, where I practiced for many years. So I was intrigued by this. In fact, if you look at decisions in the United Kingdom or in the United States, you will find that even states which have just the two-limb insanity argument, that is, did not know what they were doing or did not know that it was wrong, often somehow they can sneak in the not being able to refrain element to it. But in this, it is made explicit. So, as I said, that's in addition to the McNaughton criteria. So, in summary, what I wanted to do was to review some of the insanity cases, or in fact, some of the insanity cases in the Irish mental health system. And I'm going to compare them to, because I had access to some older figures, to what happened in the past. Particularly, I wanted to see what criteria were used in the expert reports. I was intrigued to see what did psychiatrists offer as their reasons for persons being insane in terms of those medical legal criteria. I will talk a little bit about autism disorders, that is autism spectrum disorders, and intellectual disability, that's ID there on the slide, and look a bit at future directions. I'm just going to have a quick look at at our next door neighbour jurisdiction before I go on. In Britain, that is in England and Wales, and it's similar in Scotland and Northern Ireland. A jury can return a verdict on the basis of two medical reports, and in that case, it gives the court, if the verdict is reached, for the person to be sent to hospital, but also the person may be given a community order, that is to be treated in the community, or there may be an absolute discharge. In the system in Ireland, we don't have that. The person comes to hospital with very few exceptions. I thought that it might be of interest just to show how the British system works here. And there are two cases I was involved in. One was a man who set fire to his flat, and he set fire to the flat under the delusional belief that the flat was being infected with poisonous substances. It was a jelly-like slime that was covering the tables and chairs and other parts of the furniture. And this man had become increasingly unwell because of difficulties in his life and because of changes in his care provisions. So he had therefore lapsed from taking his medication. He had lost contact with his community nurse and therefore became unwell because of those factors and because of the stresses. And the beliefs became fixed and he could not, he found them intolerable. He conceived the idea in his deluded state that by heating the material, the jelly-like material he believed that was pervading the place, he could neutralize it. So he applied heat to it. He was careful to tell me that he had not set a fire, he had applied heat. In terms of the offence, which is arson, no, it really didn't matter. In any event, a fire ensued, the fire services were called, he was arrested, and eventually he was taken to hospital, where he made a very good recovery when treatment was reinstated. In his case, there was a previous history of a schizophrenic illness, and he made, as I've said, an excellent recovery. I was proposing that should be the end of the matter. In Britain, you don't have to argue insanity or not. You can argue that the person simply requires treatment. So that was what I was offering. However, the man himself said that he wanted to argue insanity. So I had to go back, having by that stage moved to Ireland, go to England and talk about it and argue insanity with this man, successfully as it happened. And he was given a community order. The other case was one with a somewhat similar trajectory, although in a different person. He was a man who worked in a large accountancy firm. Again, he'd been under stress. He'd been asked to work in a particular project and found this very stressful and felt that people were perhaps dissatisfied with his work. That increased to a belief that he felt that people were talking about him, and then to delusion that he was being pursued by the devil. He equipped himself with a sword and went down to his local mosque. He was a Muslim man, and sought help from his religious authorities, and was then taken into custody by the SWAT team. In his case, although insanity could have been argued, in fact, a straightforward hospital order was made at court, and the case proceeded no further than that. In those cases in Ireland, now the people would have been admitted to hospital. So that's why I draw the analogies and the comparisons. So in this study, what I wanted to do was to look at the criteria that psychiatrists use for a verdict of not guilty. And in the course of doing this, because I was reviewing a series of cases over 10 years, I took the opportunity to look at some other facets of the cases. So the method was that I used the service's computerized records with the assistance of the Administrative Mental Health Act staff, and looked at all the cases of people who had been found not guilty by reason of insanity, who had been in the service since 2007, taking that as the effective first year in which the Act would have been operational. I did not look at those for whom the defence was proposed and for whom it wasn't successful. That is probably going to be part of another project, which I will add to this. And to look at the criteria, I found the reports by the psychiatrists involved in the cases. Some of those at the time of completing this presentation had not been available to me, but I think that what I found is a pretty good representation of what the trends are. So the results were, I found 75 cases for that era, that's 2007 to the current year. There was at least one report for each case. Of the cases, there were only 6 women. 12 cases had been decided under the old law, which I showed you there, but I included them because they were within the era and they contained useful information about offences and the mental disorder. And of those 75, 57 of them, I was able to extract the criteria, which I will talk about shortly. So this is the breakdown by year. For 2007, as you can see, we had 7. That is round about, as you'd expect, the mean of the referrals. It varies a bit, and there was, for some reason, a bulge in 2014, and this year so far there are 4 cases. Types of offences, that's a list of offences, more or less in alphabetical order. As you can see, homicide figures very largely, so deaths, causing deaths, is a very major part of it. So there is straightforward homicide, and there's, you can see deaths by dangerous driving, actually, 2 cases. And then there are attempted homicides. In addition to that, there is a large number of assaults. So offences against the person of all kinds are the major part of it. Small number of sexual assaults, and a few other odds and ends. So that's it in graphic form. To look back at the history of it, colleagues in 1997 did a review of all the cases that the hospital had dealt with. So these were the offences from 1850 to 1909. As you can see, there is a remarkable similarity. It's still homicides and assaults. You'll see attempted suicide among those, which is quite interesting. That was still a crime at the time. It's rather sad. And then moving on to 1910 to 1935, again, vast number of homicides, smaller number of sex offences, and the suicides have disappeared. I think the law hadn't changed by then, but I think the legal attitude had changed. Sex offences account for a tiny number. So the primary diagnosis, what disorders did the persons have at the time? And this again is in alphabetical order, but you can see, having a scan down through that schizophrenia, the general term, and paranoid schizophrenia, specifically so referred to, constitute the majority of the diagnoses. No other types of schizophrenia were diagnosed, so it was either schizophrenia or paranoid schizophrenia. Next then would come schizoaffective disorder, and as you can see, that accounts for a fair number as well. And then we have the mood disorders, the affective disorders, that is to say, a depressive disorder and bipolar disorder. So a small number of bipolar disorders and a number of psychotic depressions. And that's again in graphical form. You can see that there are a couple of other outliers as well, dementia, for example, and delusional disorders. And now, again, looking historically, what was found historically? The authors of the previous work didn't actually go back and look at the earlier diagnosis, probably because diagnostic criteria used in the 19th century and into the early 20th century differed so significantly. For example, the concept of schizophrenia was only starting to gain favour. But from 1930 to 95, you can see quite a small number of insanities, 53. Some had a tiny number had no illness. Mental handicap, which is what we now call intellectual disability, accounted for a small number. Epilepsy, interestingly, also accounted for it. I'd imagine nowadays we'd probably be looking at such entities as automatism for that rather than insanity. Personality disorder, again, which we don't reckon with nowadays. Major depression, as we've seen that in it, but again, a huge number of people with schizophrenia, and so that trend is maintained. What ages were they, the current cohort? The current cohort were mostly in the younger adult age group. You can see the bulge there is in the range of 30 to 39, but almost all are between 20 and 39. So what this shows is that the offences are all in the serious end of the spectrum. They're almost all against the person, and this shows, in contrast to contention that sometimes is offered, that insanity is not used casually. It's used only when the person faces a very serious consequence. The crime is serious, therefore the criminal justice disposal otherwise would be a very grave one. So they're used only for these grave cases. It's also of interest to see that there is a stability in the type of offences and in the types of disorders over quite a long period. So now I come to the criteria. So when I talk about the criteria, I'll remind you of those. That is, not able to understand, that the person did not understand his or her act. That's the first one. That the person did not understand that it was wrong is the second one. And finally, that the person could not refrain from committing the act. That's the third one. In 16 of the cases for which we had those details, and that is all the reports I could obtain, 16 of them chose all three criteria. So the person did not know what they were doing, didn't know it was wrong, and was not able to refrain. In 3 of them, the person chose, the psychiatrist suggested that they didn't know what they were doing and couldn't refrain from it. Then there were a couple where they did not know what they were doing and did not know that it was wrong. So those would be the traditional McNaughton criteria. As you can see, that amounted to only 2, interestingly enough. And those who did not know that it was wrong and could not refrain account for 17. Only 1 didn't know what they were doing, and only 4 did not know that it was wrong. For those who could not refrain alone, there were 14 cases. So in summary, out of the 57 cases, 50 settled on, either in combination with others or alone, that the person could not refrain from committing the act. So this meant that somehow that the person was left with no other option. I'll talk about that briefly in a moment when I come to the autism cases. So that's those are the criteria in table form. So why did the experts say this? And I looked at them and I tried to come up with a conspectus of it. And broadly speaking, what the experts seemed to be saying was that the person's understanding of the choices available to him or her because of his or her mental disorder had been so markedly constricted that they could see only one choice, that of the act which led to the charges against them, commonly a serious injury or homicidal act to a person. So they found themselves in a situation which, through their mental disorder, in which they felt they had only one option of action, and that action was a fatal or very seriously injurious to another person. So the mental disorder led to them not being able to think of any other way of dealing with this catastrophic eventuality. I want now, just because my own area, which I touched on earlier, is intellectual and developmental disability. Our service has existed for 3 years, as I think I mentioned earlier. What we're finding is that in our service, the developmental disability is actually becoming the most significant part of it. We're acquiring a very large number of people with autism disorders. When I say large, the population that we get is small anyway, because we are a criminal mental illness service. But they are constituting a significant part of it. One of the things I have constantly to point out when I'm in court is that this does not mean that people with autism are criminals. In fact, it's a very tiny, tiny minority of people with autism who come to us. But nonetheless, the point we are making is that people with autism can have a disorder that is so disabling that they can end up in the hands of the criminal justice system. I have put there behind me the DSM-5 criteria for autism disorders. As you can see, they are deficits in social communication, and those are communication by means of understanding and by means of expression. Restricted repetitive patterns of behaviour, interests and activities, and that includes great problems with coping with change and uncertainty. These are elements that led to the outcome in some of the cases. Symptoms present in the early developmental period, so that they're not due to, say, for example, the onset of new disorders, and that the symptoms cause clinically significant impairment. That last one is absolutely crucial for our cases. It is that, to my mind, which makes them matters of clinical interest rather than simply descriptive entities. You'll see I put a little footnote down there. In the autism literature, you will commonly see a non-technical term being used, that is, an autistic person having a meltdown. Commonly enough, these are things that are dealt with in the person's own sphere of social and vocational operation, so that the person will decompensate through anxiety, but they will have a framework in place to cope with this. It happens in a small minority of people with autism, but even in that small minority, most of them don't encounter any further difficulties. However, it appears that the group we get are those for whom these meltdowns, for want of a longer, more technical term, come to our attention. So I thought I'd look at some of the criteria used in autism. So here's one. This is a man who he was, if you just bear with me a moment, yeah, this chap, sorry, just, sorry. This man, his parents were divorcing, and his, he was found this extremely distressing. He had a diagnosis of autism, and he found himself trying to help his father, with whom he was living at the time, to clear the family home. He found this extremely distressing. He, at that stage, was estranged from his father, and was feeling very angry with his mother. There seemed to be some reconciliation, and at the end of the evening, when they were tidying up the house, they noticed that he wasn't there. What had happened was that, in fact, he had gone to the mother's house, and he was found there, and he had actually assaulted her. He got into a conflict with her. He felt that she didn't understand that he was so unhappy about this. He became extremely aroused and anxious, and could not contain himself, and fatally assaulted her, very sadly, and that led to her death. We argued in court that this was a culmination of events, and that this man, because of his autism, had failed adequately to understand her point of view and failed adequately to communicate his distress, and that he ended up with the only one available option, only one available course of action that he could use, and he killed her. We offered this in the court and expanded on it at length, and it was accepted. The second case is a man who had developed a preoccupation with a young woman, and the young woman eventually reported him for harassment. He was interviewed by police, and those proceedings were in hand. Together with this, he was also coping with major difficulties at work. He was a man with autism and borderline intellectual disability, but was coping all right up to then, but there had been change in his workplace. This led to great anxiety. He then had this infatuation with the young woman, whose boyfriend then tried to intercede, and the boyfriend and he got into an altercation, in the course of which he could not see the boyfriend's point of view and ended up stabbing him. He was found not guilty by reason of insanity. Again, the same process appeared to have happened, that he could not see another person's point of view. He could not see other ways of dealing with the matter, and ended up doing that. The third one is a man who tried to kill his sister because she was going to have a baby in Dublin, and he had this preoccupation with Dublin people, didn't want her to have a Dublin baby, and went to try to kill her to stop this happening. And this led, fortunately, to serious injury but not death. She managed to escape from him. And the final one was a man who, again, domestic situation, and he went to a family court where he actually attacked a judge, again for similar reasons. So these are cases of autism. As far as intellectual disability is concerned, it's interesting that even though it's my area of special interest, we don't see them. They don't come through insanity cases, and I suspect that this is probably because they are commonly enough found not unfit to stand trial, which is the other option available in court. So, final commentary. Terminology used now is more satisfactory than it used to be. We're not talking about disease of the mind, we're talking about mental disorder. The lack of alternative methods in our jurisdiction may mean that people are admitted by means of insanity rather than admitted through a court order, which is not available. In fact, that doesn't seem to happen. The third limb seems to be very popular and seems to be very useful in answer to the question I posed there. The term insanity is one that perhaps we might want to move away from, and in Britain they're considering not criminally responsible by reason of medical condition. We might move down that route. And I've commented already on the lack of insanity in cases with intellectual disability. And I will stop at that point. Thank you very much.